Good day, sir. My name is Miriam B. De La Rosa, and this video will be my final examination video for the past CLJ 302 Section D. I will be answering 20 questions starting with question number 1. Number 1. What is misprision of treason? In Article 116, misprision of treason is every person owing the allegiance to the United States, the government of the Philippine Islands, without being a foreigner and having knowledge of any conspiracy against them, conceals or does not disclose and make known the same as soon as possible to the governor of the fiscal of the province or the mayor fiscal of the city in which he resides, as the case may be, shall be punished as an accessory to the crime of treason. Number 2. What is as defined in Presidential Decree number 532? In Section 2, piracy is the penalty of reclusion temporal in its medium and maximum period shall be imposed. If physical injuries or other crimes are committed as a result or on the occasion thereof, the penalty of reclusion perpetua will be imposed. If rape, murder, or homicide is committed as a result or on the occasion of piracy, or when the offenders abandon the victims without means of saving themselves, or when the seizure is accomplished by firing upon or boarding a vessel, the mandatory penalty of death shall be imposed. Number 3. How is delay in the delivery of detained persons to the proper judicial authorities committed? In Article 125, delay in the delivery of detained persons to the proper judicial authorities, the penalty provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours for crimes or offenses punishable by light penalties or their equivalent, 18 hours for the crimes or offenses punishable by correctional penalties or their equivalent, and the 36 hours for crimes or offenses punishable by afflictive or capital penalties or their equivalent. In every case, the person detained shall be informed to the case of his detention and shall be allowed upon his request to communicate and confer at any time with his attorney or counsel. Number 4. Distinguish violation of domicile in Article 128 from qualified trespass to dwelling in Article 280. In Article 128, violation of domicile, the penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who, not being authorized by judicial order, shall enter any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of such owner, or having surreptitiously entered said dwelling and being required to leave the premises shall refuse to do so. If the offense be committed in the night time, or if any papers or effects not constituting evidence of a crime be not returned immediately after the search made by the offender, the penalty shall be prison correctional in its medium and maximum periods. In Article 280, qualified trespass to dwelling, any private person who shall enter the dwelling of another against the latter's shall be punished by arresto mayor and a fine not exceeding 1,000 pesos. If the offense be committed by means of violence or intimidation, the penalty shall be prison correctional in its medium and maximum periods and a fine not exceeding 1,000 pesos. The provisions of this article shall not be applicable to any person who shall enter another's dwelling for the purpose of preventing some serious harm to himself, the occupants of dwelling, or a third person, nor shall it be applicable to any person who shall enter a dwelling for the purpose of rendering some services to humanity or justice, nor to anyone who shall enter cafes, taverns, inn, and other public houses while the same are open. Number 5. How is the atit committed? In Article 134A, the itat, how committed? The crime of the itat is a swift attack accompanied by violence, intimidation, threat, strategy, or stealth directed against duly constituted authorities of the Republic of the Philippines or any military camp or installation, communications networks, public utilities, or other facilities needed for the exercise and continued possession of power singly or simultaneously carried out anywhere in the Philippines by any person or persons belonging to the military or police or holding any public office of employment with or without civilian support or participation for the purpose of seizing or diminishing state power. Number 6. When and how is rape committed under Republic Act 8353? In Article 266A, rape is committed, number 1, by a man who shall have carnal knowledge of a woman under any of the following circumstances. A. Through force, threat, or intimidation. B. When the offended party is deprived of reason or otherwise unconscious. C. By means of fraudulent machination or grave abuse of authority. And D. When the offended party is under 12 years old of age or is detented even though none of the circumstances mentioned above be present. Number 2. By any person who, under any of the circumstances mentioned in paragraph 1 hereof, shall committed in an act of sexual assault by inserting his penis into another person's mouth or anal orifice, or any instrument or object into the genital or anal orifice of another person. Number 7. What are the two types of robbery? The two types of robbery are, in Article 294, robbery with violence against or intimidation of persons, and in Article 295, robbery with physical injuries committed in an uninhabited place and by a man or with the use of firearm on a street, road, or alley. And also in Article 297, attempted and frustrated robbery committed under certain circumstances. Number 8. What is a false key? In Article 305, false case, the term false case shall be deemed to include, number 1, the tools mentioned in the next preceding articles. 2. Genuine case stolen from the owner. Number 3. Any case other than those intended by the owner for use in the lock forcibly opened by the offender. Number 9. How is theft committed? In Article 308, who are liable for theft? Theft is committed by any person who, with intent to gain but without violence against or intimidation of persons nor force upon things, shall take personal property or another without the latter's consent. Number 1. Any person who, having found lost property, shall fail to deliver the same to the local authorities or to its owner. Number 2. Any person who, after having maliciously damaged the property of another, shall remove or make use of the fruits or object of the damage caused by him. And number 3, any person who shall enter an enclosed estate or a field where trespass is forbidden or which belongs to another and without the consent of its owner, shall hunt or fish upon the same, or shall gather cereals or other forest or farm products. Number 10. How is qualified theft committed? In Article 310, qualified theft, the crime of theft shall be punished by the penalties next higher by 2 degrees than those respectively specified in the next preceding article. If committed by a domestic servant or with grave abuse of confidence, or if the property stolen is motor vehicle, mail matter, or large cattle, or consists of coconuts taken from the premises of the plantation, of fish taken from a fish pond or fishery, or if property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbance. Number 11. What are the circumstances considered as prima facie evidence of arson? In Article 326b, prima facie evidence of arson, any of the following circumstances shall constitute prima facie evidence of arson. Number 1. If after the fire are found materials or substances soaked in gasoline, kerosene, petroleum, or other inflammables, or any mechanical, electrical, chemical, or traces, or any of the foregoing. Number 2. The substantial amount of inflammable substance or materials were stored within the building not necessary in the course of the defendant business. And number 3. That the fire started simultaneously is more than one part of the building or local under circumstances that cannot normally be due to accidental or intentional causes. Provides, however, that at least one of the following is present in any of the 3 above mentioned circumstances. A. That the total insurance carried on the building and or goods is more than 80% of the value of such building and or goods at the time of the fire. B. That the defendant after the fire has presented as fraudulent claim for loss. The penalty of present correctional shall be imposed on one who plants the articles above mentioned in order to secure a conviction or as a means for extortion or coercion. Number 12. What is malicious mischief? In Article 327, who are liable for malicious mischief? Any person who shall deliberately cause the property of another any damage not falling within the terms of the next preceding chapter shall be guilty of malicious mischief. Number 13. Who are the persons exempted from criminal liability under Article 332? In Article 332, persons exempt from criminal liability, no criminal but only civil liability shall result from the commission of the crime of theft, swindling, or malicious mischief committed or caused mutually by the following persons. 1. Spouses, ascendants and descendants or relatives by affinity in the same line. Number 2. The widow spouse with respect to the property which belong to the deceased spouse before the same shall have a pass into the possession of another. And number 3. Brothers and sisters and brothers-in-law and sisters-in-law if living together. The exemption established by this article shall not be applicable to strangers participating in the commission of the crime. Number 14. How is adultery committed? In Article 333, who are guilty of adultery? Adultery is committed by any married woman who shall have sexual intercourse with a man, not her husband, and by the man who has carnal knowledge of her knowing her to be married, even if the marriage be subsequently declared void. Adultery shall be punished by present correctional in its medium and maximum periods. If the person guilty of adultery committed these offenses while being abandoned without justification by the offended spouse, the penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. Number 15. How is concubinage committed? In Article 334, concubinage committed by any person who shall keep a mistress in the conjugal dwelling or shall have sexual intercourse under scandalous circumstances with a woman who is not his wife or shall cohabit with her in any other place shall be punished by prison correctional in its minimum and medium periods. Concubine shall suffer the penalty of destierro. Number 16. How is qualified seduction committed? In Article 337, qualified seduction, the seduction of a virgin over 12 years old and under 18 years of age, committed by any person in public authority, priest, home servant, domestic guardian, teacher, or any person who, in any capacity, shall be entrusted with the education or custody of the woman seduced, shall be punished by prison correctional in its minimum and medium periods. The penalty next higher in degree shall be imposed upon any person who shall seduce his sister or descendants whether or not she be a virgin or over 18 years of age. Under the provisions of this chapter, seduction is committed when the offender has carnal knowledge of any of the persons and under the circumstances described herein. Number 17. How bigamy is committed? In Article 349, bigamy, the penalty of prison major shall be imposed upon any person who shall contract a second or subsequent marriage before the former marriage has been legally dissolved, or before the absent spouse has been declared presumptively dead by means of a judgment rendered in the proper proceedings. Number 18. What is libel? In Article 353, definition of libel. A libel is public and malicious imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstances tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. Number 19. What is planting of evidence under Par CC Section 3 Article 1 of Republic Act 9165 and its penalty under Section 29 thereof? The planting of evidence in Section 3 Article 1 in Republic Act 9165, the penalty under Section 29 criminal liability for planting of evidence, any person who is found guilty of planting any dangerous drug and or controlled precursor or in an essential chemical regardless of quantity and purity shall suffer the penalty of death. Number 20. How is murder committed? In Article 248, murder committed with any person who, not falling within the provisions of Article 246, shall kill another, shall be guilty of murder and shall be punished by reclusion temporal in its maximum period to death. If committed with any of the following attendant circumstances: Number 1. With treachery, taking advantage of superior strength with the aid of armed men, or employing means to weaken the defense, or of means of persons to ensure or afford impunity. 2. In consideration of a prize, reward, or promise. Number 3. By means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment, or assault upon a street, car, or locomotive, falling in an airship by means of motor vehicles, or with the use of any other means involving great waste and ruin. Number 4. On occasion of any of the calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or other public calamity. Number 5. With evident premeditation. Number 6. With cruelty by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse.